She filed the standard petition for dissolution, citing irreconcilable differences, which is very normal, and that's typically what people cite as a grounds for divorce in California. Mm-hmm. And then also she's seeking, I saw, sole physical custody, mm-hmm. but joint legal custody. Okay. I wasn't really that surprised. People obviously have the right to get a divorce if they want. It's a no-fault state in California. A lot of times people in the limelight, so to speak, perhaps have a higher rate of divorce because they have more issues that they're dealing with and having to be in the public eye all the time, and speculation about their relationship that goes on in the tabloids and newspapers. But when I reviewed the paperwork, none of it was really that surprising. It's not uncommon that a person would seek sole physical custody in their initial filing. That doesn't mean that is what they will end up seeking if they resolve the case through settlement or in a courtroom. It may end up being joint physical custody, irregardless of what somebody asked for in their initial petition. She very well could change her mind as well, and there's nothing stopping her from doing that, despite having checked those boxes on her petition. Hi, Ashley. Is my 1 o'clock appointment here yet? Okay, please tell her I'll be right with her. Okay, thank you. Mr. Pitt will have 30 days to file a response to the petition for dissolution. And then most likely, if they're not already doing it, the attorneys will meet with each other and confer and see whether or not there are issues that they can resolve without going to court. If they're not able to do so, or one party believes that there's some emergency issues that need some immediate relief, then it may be that somebody will file a pleading with the court seeking that relief. Courts aren't inclined to grant a motion for a sealing order, and the public has a right. It's a public court system. The public has a right to see what's been filed. It's all a public record. But for purposes of the safety and protection of the minor children, the court does sometimes issue a sealing order on that part of the file having to do with issues pertaining to the minor children. People, this is a very mobile society, and it's not uncommon that you have people that live half the year in one location, half the year in another location, and have other homes that they go to for vacation. So as far as the fact that they do have other residences, that really won't play into the custody decision. It'll be a determination of the best interests of the minor children. And in California, typically, or at least locally, joint legal custody is preferred, and joint physical custody is as well, unless there are reasons why, in the best interest of the minor children, the court should deter away from awarding joint physical custody.
It'd be kind of weird that the adoptive parents...
Well, in regard to the foundation, they will most likely resolve that issue between them, and if they don't, then a court will make orders regarding who should take over the foundation, and it's usually the person who was more involved managing the foundation that would end up being awarded that asset. Vivian and the twins, Vivian and Knox, I think.
Parents divorce,
yeah.
you know.
Yeah. That happens a lot.